Okay, ready to go? All right, good morning, everyone. Looks like the first individual we're going to see this morning is Mr. Maurice Buckley, followed by Mr. Michael Lopez.
I spoke with Mr. Buckley this morning. I would ask to first have the public defender appointed to his case, and then I would ask to waive his appearance.
All right, so let me double check. Mr. Buckley. Yeah, I already approved him for a public defender on the ad book case.
All right, good to know. And then I spoke with the state prior to this hearing. I believe we have a stipulated bail amount.
All right, let me check that issue too. Do we have a stipulated bail amount, Mr. Buckley?
Your Honor, I believe we've come to an agreement of $5,000 bondable with no added conditions.
Okay. All right. So $5,000, no conditions?
That's correct, Your Honor.
Accurate? Okay, so I'm sorry, you cut out. I want to make sure I've got this correct. $5,000, no conditions for Mr. Buck.
Correct, Your Honor.
What about David Nez? All right, let me get that off my JRO.
Your Honor, this was a fight at the jail.
Right.
A no contact order may create issues for the jail.
Understood. All right, so we'll have $5,000 with no conditions on Mr. Buckley. All right, again, I've gone through the PC sheet and all the other information in the file. So when we go through each one of these cases, I don't need a summary of what occurred in the PC sheet. All right, next individual is Michael Lopez. Mr. Lopez.
Yes, I spoke with Mr. Lopez today as well. I would ask to waive his appearance and proceed with the hearing.
All right, we're going to set us 72 for Mr. Lopez, correct?
That's correct.
That'll be for April 10th at 9:30.
Well,
Thank you.
April 10th, 9:30. How about a Mr. Jeremy Fuller?
Yes.
There's no jail complaint for Mr. Fuller?
Guilty.
All right. Is your client going to waive a formal reading?
Yes, we've received a copy of the criminal complaint. He is identified correctly in that document at line 7. He's familiar with the contents of the document and will waive a formal reading.
All right. And is he going to enter a plea today?
Yes, he intends to enter a guilty plea to the sole charge in the criminal complaint.
All right, so Mr. Fuller, it's my understanding, based on what counsel just said, that you'll be entering a plea of guilty to count 1. Is that accurate?
Correct.
All right, do you understand the consequences of your plea?
Yes.
You also understand by pleading guilty to that charge, you're waiving valuable constitutional rights, including your right to go to trial on this matter.
Yes.
So what is your plea to count 1, use possession of drug paraphernalia?
Guilty.
The court finds you've entered your plea intelligently, voluntarily, with a knowing understanding of each element of the charge and consequences of your plea, and the court accepts your guilty plea to count 1. All right, so how long have you been incarcerated?
Since yesterday.
Pardon me?
Since yesterday, he also got originally picked up back in August of last year, and that would be for an overnight. So I believe it's 3 days credit for 3 days time served.
All right, so 3 days credit for three days time served. All right. You have a good day, Mr. Fuller.
Okay, cool. Go back.
All right. How about Mr. Ryan Smith?
Mr. Smith refused court today. I would ask to just continue his hearing 1 day.
Okay. All right. We already have a continuance, it looks like,
It looks like you refused yesterday as well, Your Honor.
right? Do we know why he's refusing? Is he not feeling well?
Not at this time. If the court's not inclined to continue again, we can proceed in his absence.
Yeah, let's proceed, because he's only really entitled to the one continuance. All right, is the state ready to proceed?
Yes, Your Honor, we'd seek bail in the amount of $15,000 bondable, pretrial supervision with testing for drugs and alcohol and no weapons. Scores an 11 on the risk assessment. He also had the petty larceny arrest out of the Varina Municipal Court. He was arrested on a a failure to appear warrant and a contempt warrant. Does have significant criminal history. However, most recently it was a drug paraphernalia conviction from last year and a contempt arrest out of Lyon County. A felony arrest from Lyon County the year before for possession of controlled substance. He also had arrests for dissuading, domestic battery second, and obstructing that show no disposition. A misdemeanor domestic battery first conviction in 2023. He had another domestic battery arrest, this one for strangulation in 2019 with no disposition. He did have a felon failure to register conviction that same year, a misdemeanor conviction for possession of stolen property in 2018. A felony arrest for possession of a stolen motor vehicle in 2017 where no charges were filed, but he was convicted of drug paraphernalia. And then in 2012, he had a felony conviction for battery resulting in substantial bodily harm, as well as a gross misdemeanor conviction for child endangerment, a 2009 felony convictions for burglary, as well as uttering. And in a separate case, he had a felony conviction for attempted theft, where his probation was revoked, 2006 felony conviction for trafficking, and a gross misdemeanor conviction for conspiracy to commit burglary. So given that history, Your Honor, we do believe a slightly higher bail than would typically be set on this type of case to be appropriate with the noted conditions.
Right. Mr. Merritt?
Yes, I would ask for a slightly lesser amount in bail, probably to the tune of $8,000 bondable with a 10% cash option. I think that's more befitting of the factual allegations in this case and the depth of alleged injury to the community. As an alternative to monetary bail, I would also ask for an opportunity at IAP transport to inpatient or residential treatment, with Mr. Smith having a qualifying substance use evaluation on the books. Given the state's recitation of Mr. Smith's criminal history, it sounds like a predicate to much of everything Mr. Smith has done is drug use and drug abuse. I think the only way to get out of it is through intensive treatment for somebody like Mr. Smith. And I believe if we get the right setup for Mr. Smith, we can potentially change his ways and mitigate future criminal activity.
Yeah, I did admit he's addicted to fentanyl. Also said he thought the trailer was stolen. I'm gonna set his bail at $10,000. He'll be subject to testing, shall not possess firearms or weapons. Then pretrial services supervision. All right. Let me give you this thing here. All right. Next individual is Nicholas. No, excuse me.
My apologies, Your Honor. The 72-hour hearing on that case will be for the 9th. Is that correct?
Yes, that's correct.
Okay,
Fine.
thank you.
All right.
And I apologize, Your Honor. I didn't catch the name you stated.
No, actually, I want to make sure I got the right one. It's Jason Adams, followed by Nicholas Harper. All right, are we ready to proceed with Mr. Adams?
Yes.
Yes, Your Honor. In this case, the state is not going to seek bail, given the weight of the controlled substances and Mr. Adams' conduct with law enforcement, we would ask for pretrial supervision with testing for drugs and alcohol. He has 9 on the risk assessment. Looks like he has a grand larceny of a motor vehicle case pending out of Las Vegas, or at least that shows no disposition. That arrest occurred in 2024. He had spousal battery convictions from California, misdemeanors in 2020 and 2013, but otherwise no other criminal history.
Mr. Mayor, were you able to verify some of his information? Looks like he does have, if I read the notes correctly, has an active hold, out of jurisdiction hold. Is that accurate?
My understanding is that that may be the Las Vegas warrant that he originally got arrested on out here.
Correct. Okay. All right, let me just check my notes on this. So the state is okay with an OR subject to conditions?
Yes, Your Honor, given the weight, I think this will likely be filed as a no jail complaint, so I think bail would be unnecessary.
All right. All right, so he was subject to an OR release, subject to testing, pretrial services supervision would be the conditions to his release. All right, do we have a date for him?
The arraignment will be for April 22nd at 9 a.m.
Court date, where it's gonna be. That's my work phone, so with that, when you get released, let's say you get transported to Las Vegas, you stay in touch with me so I don't have another failure to appear on this case.
Yeah.
Okay? So.
Yeah, he's felon. Crime, domestic battery.
Las Vegas.
Sometimes I'll check him into that. Okay, next is Nicholas Harper, followed by William Sidock.
Thank you, Your Honor.
Your Honor, I do believe that we will have the victim present on Mr. Harper's case. I would ask if they're present.
Yeah, we're admitting him.
Thank you.
All right, has your office had a chance to speak with the victim, Mr. Harper?
Yes, Your Honor. It's my understanding that Mr. Harper, Bradley Harper, the victim in this case, is not seeking a no contact order. He did express his concerns, though, regarding the defendant, Mr. Harper's increases in drinking recently. Given the facts of this case, Your Honor, that the defendant, Mr. Harper, scores a 5 on the risk assessment and has no criminal history as an adult, I would not object to his own recognizance release. However, I would ask that he be subject to pretrial supervision, daily testing for alcohol, have no firearms or weapons. And as Mr. Harper, the victim in this case, is not seeking a no contact order, the state will not be seeking one.
All right. So he currently resides with his father, but the notes indicated he had another place to live. So is Mr. Harper, Bradley Harper, going to make a statement in this case? Did he want to speak?
If you do wish to make a statement, Mr. Harper, you can go ahead and unmute your phone and address the court. You're currently muted, so we can't hear you.
Can you hear me?
Yes, sir.
Yes. Do you want to make a statement, Mr. Harper?
Yes, I'm just a little concerned about the alcohol use, and I would hope that the court would see that maybe he can get some enlightenment through a alcohol program. And the other thing I'd like to say is he's welcome to come home.
All right.
And with that being said, that's all I have to say.
All right. Well, I did flag Mr. Nicholas Harper as a potential OR, given his low risk assessment. Although I had him residing somewhere else with a no contact. Nevertheless, he is going to be OR released. I'm going to eliminate the no contact in my JRO to be subject to daily alcohol testing, pretrial services, supervision. All right.
And Your Honor, given the victim's wishes in this case, I think it would also be appropriate to include some forms of AA or other non-denominational treatment.
He'd be eligible for specialty court, wouldn't he?
I believe so, Your Honor.
All right, so I've added those two other conditions. All right,
And my apologies, Your Honor. Did you also include a no weapons clause?
I did.
Thank you.
All right, so Mr. Harper, you're gonna be released pursuant to those conditions. All right. You need to get some treatment. You understand that, sir?
Yes, sir.
All right, you have a good day.
Thank you.
An arraignment will be set for April 22nd at 9 a.m.
All right.
Thank you, Mr. Harper. You're free to log off. If you have any questions, please feel free to reach out to my office.
Okay, thank you, sir.
Take care, sir.
Bye-bye.
Set up with PSS.
Yes.
Okay, I can get that real quick if they want to bring it back so that he knows the date.
All right, is he still available so we can give him his PSS date?
No, but I can
I
have
never
it
read my
forwarded
rights.
to him.
All right, so what is that date?
I never read me my rights when I was arrested.
Yes,
In this case, being
'cause I'm
dismissed.
referring him to cap court.
All right,
What does that mean?
not you.
Oh, okay.
So we'll do April 8th at 2:30 p.m. for his appointment with specialty court.
All right.
All right, are we ready to proceed with William?
With Mr. Syduck, yeah.
Yes.
They also took money out of my wallet and didn't replace it. Here in the sheriff's department, they took $373 from my wallet and said I only had 249.
Well, first of all, hold on a
Mr.
second.
Syduck.
Oh,
No,
Make sure
please
we
don't
have
make
these
any
first.
statements.
Yes.
You want to make a statement, talk to your lawyer first.
okay.
All right? All right, is the state ready to proceed?
Yes, Your Honor, we're seeking bail in the amount of $5,000 bondable, pretrial supervision, and no weapons. Mr. Syduck, facts are concerning in this case, making homicidal statements, armed with multiple knives when contacted, and had the brass knuckles in his possession. Given the likelihood of conviction in this case, we believe that bail is appropriate, especially given the defendant's statements. Scores a 10 on the risk assessment, noting 2 points for prior crimes of violence. Most recently, he was arrested on a destruction of property case this year that was no issue by my office. Prior to that, his criminal history is all out of the state of Ohio. He does have multiple other crimes of violence, a misdemeanor conviction for assault in 2025, disorderly conduct that same year, felony conviction for making terroristic threats, and misdemeanor aggravated menacing ×2, disorderly conduct misdemeanor conviction that same year. In 2021, he had a felony conviction for intimidating a public servant, a 2008 felony conviction for receiving stolen property, as well as drug paraphernalia and possession of controlled substance misdemeanors, a 2006 felony conviction for resisting arrest, misdemeanor public indecency, 2 separate cases with 2 convictions, a drug paraphernalia and another public indecency. Then in 2005, a misdemeanor conviction for domestic violence and a 2002 misdemeanor convictions for aggravated stalking, misdemeanor assault, and misdemeanor conviction for criminal damage. So given that history of violence, Your Honor, we believe he presents a ongoing risk of further criminal activity and risk to the community, and we do believe bail to be the least restrictive means.
All right, do we have a response, Mr. Merritt?
Yes, Judge. In speaking with Mr. Sydock, we do have SB 89 concerns. We would ask that bail be set in the interim until we can get to the bottom of those concerns.
All right. I think that makes, I think that's a very good recommendation.
This is going to be a note for somebody
All
else.
right. So the
Okay.
bail is only gonna be interim in this case. All right, in order to obtain an SB 89. All right,
Will that include all conditions as requested as well, Your Honor?
yes.
Your bail?
And then the next
So,
individual is gonna be Ruben Solis.
Thank you. I agree, Your Honor.
And then, Madam Clerk, I just have a quick question back on Harper. What was the cap court time on April 8th?
2:30 PM.
2:30, thank you.
All right, we're ready to proceed on Mr. Solis.
Yes, Your Honor. In this case, similarly, given the weight of the narcotics and his conduct with law enforcement, we are not going to object to Mr. Solis's release in this case. We'd ask for pretrial supervision with testing. Scores an 11 on the risk assessment, noting that pending case and 2 points for prior substance abuse related arrests. He does have a rather lengthy history, but given the underlying facts of this case, we do believe the own recognizance release with supervision and testing to be the least restrictive means.
All right, let me just double check my notes. And Mr. Merritt, it did indicate, I mean, his information could not be verified, but it did indicate, is he currently living at the shelter? 610 Line Drive?
Yes, he's indicated to me that he intends to return to the CARES campus.
All right. All right, so you're gonna be released, sir. You're gonna be subject to testing, pretrial supervision. And I'm gonna require that you live at the CARES campus, all right?
Yes, yes, sir.
Will supervision include testing, Your Honor?
Yes. Yeah, it's one of my boxes that I checked.
Thank you, Your Honor.
All right. Next is Dominic Harris.
And then arraignment for Mr. Solis will be April 22nd.
Yes, at 9 AM.
All right. Next court date. Yeah. You gotta make
Yeah,
sure.
I'll just let you call that out. All right.
Don't breathe out. Okay.
Would you pre-trial, where's that at? I'm not from Reno, so gotcha. I would go straight to Reno Justice Court. So, Cindy, to Harris Street. Yeah. It's downtown and up to the river.
Okay. Mr. Heydrich, are we ready to proceed on Mr. Harris?
Yes, Your Honor. The state's, I don't know, Mr. Merritt.
Yes, and speaking with Mr. Harris, we will be able to proceed without him being physically present.
Okay.
Your Honor, the state's going to seek bail in the amount of $1,000 bondable and no additional conditions except court supervision. He scores highly on the risk assessment at a 13, does have significant criminal history, most recently a felony convictions for felon in possession of a firearm and carrying a concealed weapon last year in CR 252018. Looking at only prior felony convictions, he had a felony conviction in 2018 for use ID with an intent to defraud out of California. A 2017 felony conviction for, again, use ID with intent to defraud. A 2016 felony conviction for taking a vehicle without consent. A 2015 felony conviction for possession of a controlled substance. So, Your Honor, given that history, we think that some monetary bail is appropriate, but given the facts of this case, a low monetary bail and court supervision to be the least restrictive means. It looks like he is likely going to be held on that PMP case as well.
I want to make sure the conditions would be subject to testing, shall not possess firearms, pretrial supervision.
I didn't request testing, Your Honor. I didn't think there was a sufficient nexus given the facts of this case. It is just the obstructing false name. So my only request was the $1,000 bondable and court supervision.
What about firearms?
Well, given his history, Your Honor, I think that's appropriate. But
He scored a 2 with substance abuse.
he does have history, Your Honor, with substance abuse related arrests, but most recently it looked like a 2011 misdemeanor conviction for possession of marijuana for purpose of sale. So given the conviction history, I thought it was a little too remote to require testing, as no narcotics were listed in the probable cause.
All right. Mr. Merritt?
Yes, we will stipulate to the monetary bail amount as suggested by the state. And then in terms of supervision conditions, I think just check-ins with pretrial would be appropriate. And I don't think testing at this time would be appropriate given the lack of any substance or alcohol being used in this case.
All right. Yeah, he was the one, right? So we forgot to put a PC sheet. So I've already appointed a public defender. All right, Mr. Harris. Okay, here's these two. All right.
So court supervision will be the sole condition, Your Honor,
Yes, except for firearms.
and no firearms.
All right. How about Mr. Carly Hoyt? Followed by Mr. Christopher McPherson.
We attempted to speak with Ms. Hoyt. She is currently unwell. We would ask to continue one day.
All right. No prior continuances?
No, Your Honor.
All right, we'll continue, Ms. Hoyt. How about Christopher McPherson?
We attempted to speak with Mr. McPherson. He refused contact today. We are prepared to waive his appearance and proceed with the bail hearing.
All right, state ready to proceed?
Yes, Your Honor, I do believe we have a stipulated bail amount on Mr. McPherson. The state's going to request bail in the amount of $25,000 bondable, pretrial supervision, testing for drugs and alcohol, and no contact with Meadowood Mall. I'm happy to go through a recitation of the criminal history and the NPRA, Your Honor. I think it supports that amount, but I do believe, given the stipulation, that could be avoided if necessary.
And that is accurate, Judge.
All right. So the entire Meadowood Mall, not just Dick's Sporting Goods?
Yes, Your Honor.
All right. All right, and testing and pretrial services supervision, correct?
Yes, Your Honor. And Your Honor, he does have prior felony convictions if you would like to include a no firearms condition as well.
Yeah, I did. Okay. Okay, next individual is Jameen Robinson, followed by Randy Ray Stein. All right, state ready to proceed with Mr. Robinson.
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $10,000 bondable, pretrial supervision with testing for drugs and alcohol, no driving without sufficient documentation, And as Mr. Robinson is a felon, no firearms. Scores an 8 on the risk assessment. Given the weight of controlled substances, 15 grams gross weight total. I would also note that he did have the scale with residue, and it was in charge, but it does look like there was sufficient facts in the probable cause to establish open container as well. Mr. Robinson scores an 8 on the risk assessment. His criminal history includes a 2023 felony conviction for battery with a deadly weapon locally. Then he had a 2014 felony conviction for trafficking, 28 to 72 grams locally. A 2013 felony conviction for robbery locally. A 2005 felony conviction for sale of a controlled substance. A 2004 felony conviction for robbery with a deadly weapon, misdemeanor domestic battery in 2004, as well as a gross misdemeanor conviction for attempted theft. Looking at only prior felonies, he had 2002 felony conviction for possession of a controlled substance. Again, in 2000, another possession of a controlled substance felony. A 1997 looks like battery resulting in substantial bodily harm, and a 1993 felony conviction for attempted embezzlement. Your Honor, given that history, we do believe bail is appropriate in the least restrictive means with the noted conditions.
All right, Mr. Merritt.
Yes, we would ask for a lesser amount in bail to the effect of $5,000 bondable with a 10% cash option, and also with an alternative of direct transport to inpatient upon bed availability. The reason why we're seeking that lesser bail amount is just given the underlying facts of the case, understanding that he does have a lengthy criminal history that varies. The underlying facts of this case are very slight in terms of harm to the community and danger to oneself. It is very much so a reflection of his lack of economic stature and his current placement with his drug abuse and drug addiction. In addition to that, his score of an 8 on the MPRA would warrant a downward departure from what the state suggested for the monetary bail amount. In speaking with Mr. Robinson, he reports to us that he does currently have a job, he does have a place to stay, and he does have a personal phone, but he also recognizes that he does have a drug issue and he would likely benefit from some treatment. And that is why we are also seeking in the interim, or I guess separate to the monetary bail amount, that direct transport opportunity. Because again, it seems as though Mr. Robinson is just having a tough time with his drug abuse. And the only way to get through that is through treatment, particularly a structured approach that you would get through intensive outpatient or inpatient. It's not going to go away by merely just keeping him in custody. You also look back at his MPRA score in that there are no prior failures to appear within the past 24 months and no multiple substance use arrests. That mitigates any threat of being a flight risk, which would hopefully assuage any concerns as to whether or not Mr. Robinson would actually go to treatment and complete treatment while pending this case. So we would ask for that $5,000 bondable with a 10% cash option and an opportunity at direct transport to inpatient in the interim.
So were you able to independently verify his personal information and his address, as well as his employment?
No, we were not able to. His contacts would be on his phone, but he didn't have that opportunity to pull some of those contact numbers before being booked in.
The state opposed to a direct transport to inpatient?
Your Honor, given the not recent, but 11-year-old, 12-year-old felony conviction for trafficking and prior conviction for sale of a controlled substance, I would be objecting to treatment in this case.
All right, just bear with me while I go through my notes. Again, on his failures to appears, he did score a 0. State hasn't found any failure to appears within the last 24 months, correct?
Correct, Your Honor. In fact, I did not see any failure to appears going back a significant time. I would have noted them in the criminal history.
All right. So I'm gonna agree with Mr. Merritt in this case. I'm gonna set his bail at 7,500. I'm gonna allow a direct transport to inpatient if he's able to obtain a bed. All right. He must reside at 950 Henry or Parkway, which is what's listed in the court services notes. He'll be subject to testing and pretrial supervision. All right. So if he's able to get a direct transport, then bail is moot at that point. Otherwise, he'll have to post that amount. He's not able to get a direct transport to inpatient. All right.
All right.
You don't wanna show the court and state that we're from him. Make sure you don't fuck up. Okay, what do I need? The training will order substance use.
I might need some help with those notes.
Based on the results, and then forward it over to the main assistants, then we'll start sending them. So you got a request, qualifications.
All right. How about Mr. Stein, followed by Nathan Neal? Okay, is the state ready to proceed with Mr. Stein?
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $10,000 bondable, pretrial supervision with testing for drugs and alcohol. Mr. Stein scores a 15 on the risk assessment, noting having only scored 0 points for prior failure to appears within the last 24 months. However, he does have a history of failing to appear outside of that window, Your Honor. His criminal history includes a gross misdemeanor conviction in 2022 for unlawful taking or taking a vehicle without consent locally. He also, or out of the 9th Judicial District Court, he also had a felony conviction that year for assault with a deadly weapon. In 2021, he had a felony conviction for threatened crime with intent to terrorize out of California. He had a fugitive arrest locally in 2019, was convicted of misdemeanor resisting out of this court, had obstructing and resisting, and 2 probation violation convictions out of Carson that same year. In 2017, he had a felony conviction for possession of a controlled substance and possession of drug paraphernalia with Schedule I controlled substances out of Arizona. In 2016, he had 3 failure to appear arrests in California. In 2012, he had 2 failure to appear arrests as well as a felony conviction for possession of a controlled substance. A 2008 felony arrest for possession of a controlled substance that was deferred after drug court in California. Parole violation arrest in 2004 and 2003 in California, and then a 1999 felony conviction for violating the USCA, as well as a conspiracy conviction in Arizona. So, Your Honor, given that history, we do believe that Mr. Stein would not be appropriate for treatment in this case, given the prior drug court and continued use of controlled substances. We also think that given that high risk score, bail is appropriate in this case with testing and supervision.
All right, Mr. Merritt.
Yes, in terms of monetary bail amount, I would ask for $5,000 bondable with a 10% cash option, just given the potential charges that Mr. Stein is facing. I think that would be appropriate. I would also seek direct transport to inpatient upon bed availability. I do understand the state's concerns just regarding the criminal history, but also the prior opportunity at specialty court, based on my review, is over a decade ago, almost 2 decades ago. And I understand that since then, Mr. Stein has seemingly relapsed and gone back to his addiction. I think all the same, it's important to keep in mind that dealing with drug addiction is not a linear course of action. It fluctuates, there's highs, there are lows. And that's not to say that even though Mr. Stein got treatment previously, that treatment wouldn't work this time around. especially if we keep it in a structured environment, especially because, now Mr. Stein stands here today, 2 decades older, likely 2 decades wiser, more mature, and more likely to actually care about taking his treatment seriously if afforded that opportunity. I think, again, with the factual allegations and where Mr. Stein finds himself, it's likely a result of his drug abuse, and there's only one fix. That's through treatment. Continued jail time is not going to change anything. It's just going to maintain the status quo. So we're seeking that $5,000 bondable with a 10% cash option or direct transport through IAP to inpatient.
All right, well, this case is different than the prior case, based on the rendition of his criminal history. So I'm gonna set his bail at 10,000, subject to testing, shall not possess firearms or weapons, pretrial supervision, and he's not a good candidate for a direct transport. All right. How about Nathan Neal?
And Your Honor, we do have Mr. Mang from my office who will be covering this case.
All right. And then to confirm at the jail, is Mr. Neal the last individual?
That is correct.
All right. All right, is the state ready to proceed?
Yes, Your Honor. Can Your Honor hear me?
Yes.
Thank you, Your Honor. I just want to briefly reference defendant's history. In 2017, in 17 SCR 01980, defendant was arrested on a possession of a drug paraphernalia. After 3 bench warrants in that case, he picked up a 2018 case where he was caught with using meth and heroin. He was given diversion on a felony with the 2nd Judicial District Court. He had one of the worst performance while on diversion. After 3 separate violations, including possession of stolen property, evading police officer, possession of a stolen property, he had a needle struck in his hand. He failed to report. He was revoked on May 3rd, 2023. So even though that case was from 2018, he was revoked almost more than 5 years later. In 2019, the defendant was arrested in a evading case where the defendant used a false name. He had meth in his vehicle. In that case, he pled to a misdemeanor possession of a drug paraphernalia. In 2025, Your Honor, just last week, I conducted a preliminary hearing without the defendant's presence on a luring a 15-year-old in an operation. Defendant tried to have a 15-year-old masturbate for him, conduct fellatio. When he was arrested by the officers, he had sex toys and drugs in the car. Worse, what's before Your Honor today is one of the most shocking amount of child pornography on this defendant's cell phone. The amount of CSAM is absolutely shocking. Its distribution, defendants actively in multiple groups transmitting CSAM material. It's just shocking. Just a couple examples. He had a computer screen of a 14-year-old performing sexual act on an 11-year-old. He had a 16-year-old performing sexual act on a male adult. There are 48 CSAM videos in a particular group with the defendant stating, I plan to eventually share it all here. I haven't seen it myself, but the cell phone data shows there are 21,000 videos that could be CSAM material. On July 27 of 25, the defendant sent a CSAM video where a young child appeared to be between 1 to 3 years of age was sexually assaulted for 1 minute and 51 seconds straight. Your Honor, the legislature just recently made it more penalty for these type of cases where each photo can be charged individually. But in addition to that, it's always been a severe charge for distribution, which carries 1 to 15 years in the Nevada Department of Corrections, Your Honor. Defendant's shocking amount of danger to the most vulnerable population in this community is aggregated by his continued deception throughout the current case that's already bound over to district court and his abysmal performance throughout all his cases in this jurisdiction. Just this Wednesday, he was supposed to be in court for a preliminary hearing on that Lauren case. The defendant appears to not even be truthful with his counsel. His counsel provided and did a lot of work to get defendant into treatment after he bailed out on the Lauren case. The letter we received indicates that the defendant was supposed to be released this Friday, yesterday. Yet, the defendant was not in the Reno Behavioral Center where the letter he provided indicated where he was supposed to be. He was not treating. He was at home. When he was arrested, what happens? He had drug paraphernalia in his vehicle. There is no amount of, frankly, in my mind, that can help this community, prevent this community, the most vulnerable population, from being victimized by this individual. There's no amount of condition that's sufficient for this individual with deception, with abysmal performance. Your Honor, with that, the state's request is $3 million bail, high-level electronic monitoring, absolutely zero access to computer, if released, zero access to computer, cell phones, including his mom and his grandma's cell phone, electronic devices, laptop, zero contact with daycare, school, or anywhere children might appear, arcades, random drug testing, including a drug patch. I don't believe that's sufficient, frankly, Your Honor, but that will be the state's request.
Okay, Mr. Merritt.
Yes, at this time, we're seeking a lesser amount in bail, but bail all the same, to the amount of $50,000 bondable. We will submit on the state's requested supervision conditions. I think just given the factual allegations, they are probably appropriate. We're seeking that lesser amount in bail because, one, Mr. Neal doesn't have the financial resources to post the bail amount that I've suggested, let alone the one that the state is seeking. $3 million bail is quite excessive, even with this case and these factual allegations. I do think with those supervision conditions, even though Mr. Neal will not be able to get out on the bail I suggested, if he were to, those supervision conditions suggested by the state and that we have stipulated to would likely be sufficient to mitigate further harm to the community and also ensure that Mr. Neal can make future court appearances. With Mr. Neal's criminal history, I think by and large, it tends to orbit drug use and drug abuse. It's clear that Mr. Neal has an issue. And then with these ongoing matters, it's clear that whatever is going on, the community has an interest in getting to the bottom of it. And the best way to get that to that end is having Mr. Neal remain in custody. That's why I'm seeking $50,000 bondable with the stipulated pretrial release conditions that the state has already suggested. And again, Mr. Neal, while these factual allegations are appalling, Mr. Neal does have the presumption of innocence at this time for both matters. I would hope and encourage the court to keep that in mind when setting a bail amount. That's why I still believe that $50,000 bondable is appropriate.
Well, not given the facts of this case, plus he was on active pretrial supervision. and he doesn't seem to be able to comply. But I am gonna set his bail at $2 million, no 10% cash option. He's subject to residential confinement fitted before release, subject to testing. Shall not possess firearms or weapons, pretrial services supervision. Again, this is all if he's able to post. I don't think he's gonna be able to post that amount of bail. No social media, phones, computers whatsoever. And he needs to stay 1 mile away from daycares or schools. All right,
Thank you, Your Honor.
all right. All right, so that looks like he was the last individual, so I'll see you tomorrow.
Thank you, Your Honor. We'll see you
Happy Easter.
tomorrow.
All right.
Take care.